Hi everyone, Armine Bazikian here from Bazikian Law Group. I am an attorney here in California and a certified specialist in estate planning, trust, and probate administration. This month I wanted to talk to you about the age at which it's appropriate to think about preparing a will or a trust. And so this is something that I think many people wonder. There's a misconception that you need to be much older before you create your estate plan, nearing your end of life, when your kids have already gone away to college and have their own lives, but that is absolutely not true. Anyone can have an estate plan. By definition, an estate plan is just a compilation of documents that address different scenarios in life. And so even an 18-year-old can have a very basic estate plan that addresses some concerns that that 18-year-old might have. So for example, let's say we have John, he's 18 years old, he's getting ready to go off to college. He has his own checking account that his parents deposit money into for his spending, and he is 18, so John no longer is under the guidance legally of his parents, which means that he can make all the decisions himself. He doesn't need his parents' signature for anything. So if John goes away to college, we want to make sure that if something happens to him and he's in the hospital, his parents have access to the information. So John might want to put together a healthcare directive or a healthcare authorization allowing his parents to have access to his medical information from far away, from a distance. We might have to put together a power of attorney for finance for John, allowing in a case where he's not able to do things on his own, let's say he's very ill, allowing his parents to take control over his accounts. We might actually put together a digital power of attorney, which allows John to be able to actually give rights to his parents. And I'm using his parents as an example, but this could be anyone. So John can give the right to anybody to control his digital assets or his digital accounts. So usually for health, finance, and digital, those are the three areas that we're most concerned about when it's a young person and they don't really have assets. We're not doing the estate plan for probate avoidance. We're actually doing it for incapacity planning, meaning if he's too ill to do things on his own. But the threshold amount that you need to be concerned about is about $166,000 in California and some change. If you have assets that are valued at that amount or higher, then by definition, if they're non-beneficiary designated accounts, those assets will go through the court system. So you want to make sure that you do have a trust in place that takes care of it. So that was it in a nutshell. It does not matter how old you are. You should all have an estate plan, even the very basic kind of estate plan, and make sure that you have put into place some provisions and documents that will address your concerns. Have a good one. Thanks, everyone.